This opening matters more than it sounds. By waiving his right to appeal, Enrique is locking in the outcome unless there's a rare procedural error. In plain terms, once he pleads guilty here, there's no rewind button. Question for you: how many defendants truly understand what they're giving up at this moment?
Your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
To count one, how do you plead?
Guilty, Your Honor.
To count two, how do you plead?
Guilty, Your Honor.
The tone shifts immediately. This isn't just another DWI case, it's the portrait of a life unraveling. Probation violations, addiction, family pressure. Courts see these stories every day, but what matters isn't hardship, it's whether accountability finally shows up.
24 CR 3163, State of Texas versus Enrique Seriano. All right, you entered a plea on January 13th. A guilty offense of driving while intoxicated, third or more. According to your plea bargain agreement, the state recommends community supervision. They're asking that your punishment be assessed at 4 years in the prison. All right, anything you wish to say on behalf of your client?
Would you explain to you're applying for probation, is that right?
Yes, applying for probation.
And tell her about your family and what's happening with you.
So back in November, my wife lost her grandpa, and she was having like breakdowns. So she got prescription medication, which is I think like eskeletopram. So she was taking that for a couple weeks, and then she had like a screening for a hernia. So she had stopped taking them for the whole week. That caused her to get a mental illness. So she had to get hospitalized at the specialty transplant hospital for psychosis and bipolar 1. So that caused a whole bunch of stuff. She can't drive. I have to take care of her basically. And she relapsed back in January, still with the same thing, psychosis and all of that stuff. So I had to take 2 months off in order for me to take care of her. I just recently started working again in January, but I still got to take care of her. I got to take care of my 2 kids. I got to go to work. So I'm the only one in the household working now. So I'm the only one paying all the bills. I got 2 car notes, rent, my kids' food, things like that. So I'm picking my kids up from school. I'm the one taking them to school, picking them.
Here's the core conflict: family obligation versus court-ordered treatment. The judge isn't dismissing his struggles, but the law doesn't excuse substance abuse because life is hard. Inpatient treatment isn't punishment, it's control. And control is what probation is built on.
Your problem is that they're asking for inpatient treatment. That's what we need to get to the point. So what you're giving me is reasons why you don't want to do inpatient treatment, but it's not addressing the underlying problem, which is they say you need inpatient drug treatment.
Judge, if I could.
Excuse me, we're on the record.
I would hope that you could give him intensive outpatient treatment and hold that other in abeyance, because I think he's going to do well with that, but he's got to help his family. He's got to be there for them.
State.
State agrees with the recommendation of the supervision department.
All right, the recommendation says inpatient treatment, or they say I could consider intensive outpatient treatment. How many children do you have?
I have 2 year old,
What are their ages?
8 and 6.
And what is your work schedule?
Tuesday through Saturday, 10 to 7.
That's 10 a.m.
Yes, ma'am.
to 7 p.m.
Yes, Judge.
All right, so who's looking after children during those times?
My wife is.
So I
Yeah.
mean, he trusts her to look after the children from 10 a.m. to 7 p.m.
Do you have any other help with you?
We do have a support system, yes.
Who's your support system?
So family members, family friends, we recently moved, so my brother's down the street now. But it was very intensive as far as like getting her stabilized. So we have been seeing her psychiatrist, on a monthly basis. So she's really stable. So she's able to watch the kids. She's not a danger to herself or anyone around her. It was just the relapse. she still can't drive and none of that.
This is where the record catches up to him. Prior DWI probation violations termination. Judges have long memories when patterns repeat. Probation isn't about second chances forever. It's about proving you can follow rules when no one wants to keep watching.
Problem is you've been on probation before for DWI. And there's a motion to revoke file. And you were continued. And then you were terminated unsatisfactorily. Is there anything else?
Yes, that's what we're asking for. It's an outpatient.
All right, this is what the court is going to do. The court is going to sentence you to 4 years in the prison, suspended and probated for 4 years. There's to be regular reporting by Zoom or in person. There's going to be proof of employment within 30 days. No employment as a home health care provider or with minors. A 2-year license suspension. There is to be victim impact panel live, DWI education, regular random UAs, ignition interlock for half the term, 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month for 6 months. There's to be a referral to felony drug court. That's to be in custody. If not accepted, then SATF. And what I can tell you is felony drug court will see you before the week is out. All right, so have a seat in the box. They'll take you into custody. There's a new number 1, and there are 2 violations of condition number 41. So why are you all not proceeding on those violations?
Not aware of why that's, Judge. I was just instructed by the attorney assigned to this case that they just wanted to withdraw the MTR and hold off on proceeding before that new number 1 was ready. That would probably be the strongest basis to argue for revocation.
Well, you all need to confer because he has a violation of conditions number 41. That means that if those are true, there's something that needs to be done because obviously if that was true, there's something wrong with his UAs, maybe, I don't know. And he's on probation, driving while intoxicated. So do y'all want to talk to probation about that?
We have a little bit, Judge,
Okay.
about potentially altering and amending.
Well, is the defense in agreement to altering and amending?
Judge, we've talked about altering, amending and adding a couple of conditions.
And what would those be?
ISP, there were 4 meetings, potentially GPS if he is able to bond out. I think the bonds are fairly high on his new cases. But while I think that's unlikely, we put a few conditions in place for that.
Alter and amend to include, sorry, you're all requesting full GPS?
Yes.
All right, so there'll be full GPS. Waive fees. All right, there'll be 90 sober meetings in 90 days. All right, is there anything else?
There you go.
All right, thank you. Thank you. 2025 CR 008253, State versus Enrique Sariano. Can I have parties announced for the record?
Nicole Yates for the state of Texas.
Ron Walsh for the defendant.
And are you Mr. Sariano?
Yes, Your Honor.
And this is the moment everything collapses. The case detonates from supervision issues into first-degree felony charges. Possession cases like this carry staggering ranges, 5 years to life. What started as a probation review has now permanently altered the trajectory of this case.
All right, did you understand in count 1, your charge is possession of child?
Yes, Your Honor.
And count 2, you're charged with, I'm sorry, in count 1, you're charged with possession as a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison. In count 2, you're charged with possession as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, count one, you're to be sentenced to 18 years in the prison. Count two, you're to be sentenced to 2 years in the prison. They're requesting that the counts run concurrently. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
To count one, how do you plead?
Guilty, Your Honor.
To count two, how do you plead?
Guilty, Your Honor.
State any evidence.
State tender states one and all attachments pending objection.
No objections.
Court will accept into evidence states exhibits one and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
All right. Why should I follow this plea bargain agreement?
Your Honor, I would ask you to follow the plea bargain agreement. The first degree charge stems from an incident where you will be likely charged in a different county. The other possession charge is probably on the spectrum of what I see, the least offensive.
None of these cases are good, but as far as the spectrum, it's a lesser one. And these were primarily photos. I don't know if he took them or he had them on his phone or nap, but there was a minimum number. There wasn't a tremendous number of them. So it's a substantial amount of time for this. It's not penetration. It's not that kind of stuff.
All right. Count one, the court will sentence you to 18 years. And count two, the court will sentence you to 2 years. Court will give you credit for any time served. Count one and count two legally must run concurrently. There's to be no residing in households with minors. There's to be no contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. Do we still have the pending MTR?
Your Honor, no, he was continued on probation for that DWI several months ago. Well, and he's been incarcerated ever since.
Well,
I'm not aware of an MTR being filed.
do you want him revoked on that, or do you want him?
We're like to be revoked on that, and
All right. So if you'll speak with probation. All right, Norma. On his other case, the motion to revoke, a motion to revoke hasn't been filed. Just recall that for the 17th. Are you available on the 17th?
that's Monday.
Yes.
Later in the morning, I should be.
All right. Norma, recall this for the 17th. And that'll be on the motion to revoke.
Your Honor, does state need to be here?
No, there's someone else to be here.
The courtroom goes quiet because the scale has changed. This isn't about recovery anymore. It's about protection, punishment, and permanence. The system didn't escalate overnight. It followed the evidence step by step. And now the question isn't rehabilitation. It's whether there's any road back at all.
Yes, it's 2024 CR 3163. And I imagine they can just put this case in the motion to revoke. All right.
Could they withdraw that motion? Would that resolve it?
No. Well, there's not a pending motion to revoke. So if you all want to just have the motion to revoke filed, then that will be taken care of and he won't be on probation.
Well, he's gonna be in jail anyway. I mean.
Yeah. It's up to y'all, but I'll see y'all back on the